You can reserve up to 5 minutes for rebuttal if you wish. Just let me know, and I will help keep time for you.
May it please the court, my name is Michael Stepanek. I represent defendant, appellant, and cross appellee James Burge. Your Honors, what we're here for today.
Do you wish to reserve any time?
I'm sorry, I wish to reserve 4 minutes for rebuttal if I could. What we're here for today is a very unique case. You have a sitting judge indicted for what we would argue mistakes on his financial disclosure forms. I had not seen through our research anybody else indicted for felonies for this before. And what we have here are convictions on 2 different charges: falsification, requiring that Attorney Burge, or Judge Burge at the time, had made false statements on his financial disclosure forms. And that led to the falsification charges, and then for tampering with records, that he, with a purpose to defraud, falsified his financial disclosure statements. The particular thing about all of the financial disclosure statements and the things that in particular he was accused of falsifying or changing in order to defraud those are all things that had legally supportable positions behind them. A couple of, for instances, he had been charged with omitting his ownership in a business, Whiteacre North. And I'm not going to go through all of the different elements, and the brief was kind of long enough in that regard, but there are legally supportable positions, and in the record, his attorney even testified, look, we went to great lengths to make sure that Attorney Burge was divested of his interest in this by an assignment to his wife. And then all of a sudden, individuals from the Ohio Ethics Commission come in and testify, well, in our opinion, we think that he should have included it. Well, the difficulty is it possible to know, in terms of falsification, that your legal opinion is false? And I think that for all of these things, there are legally supportable conclusions that could be drawn to say that he didn't own an interest. For instance, there is, for counts 5 and 6 in the indictment, he's charged with falsification and tampering with records for not putting Lorain National Bank as a creditor in his financial disclosure form. Now, a couple things about that. The only evidence that was presented at trial regarding him being a creditor came from Attorney Nick, who came from the Department of the Ohio Ethics Commission and said, well, since you should include you being a co-signer on a loan, then if you're in a guarantor agreement, you should probably include that as well. Well, in our brief and at the trial court, we were able to show that a guarantor only owes money in the event of a default. I think even in the state's brief, they had put that the fact that Judge Burge would only owe money upon default shouldn't change the fact that he should report this. Well, a creditor is someone that you owe money to. A guarantor is somebody who doesn't owe money to anybody unless there's a default. So they said, well, you should have considered yourself a creditor. Well, based on what? And he has legally supportable positions to say, look, there's case law saying that I don't owe money to anybody, so I don't include it. Now, you could also argue that for that, he had included it in several other years. Perhaps that was wrong, but the point is, how do you say that he knew as a matter of fact and a matter of law that he was not a creditor, that that his assignation of his interest in Whiteacre North was maybe somehow not effective, so he knew that as a matter of fact? There's really nothing to support that in the record. The third thing is that he was also charged with falsification for not including his wife's interest in a business, Whiteacre North. Again, individuals came from the Ohio Ethics Commission and said, well, we think you should have listed it in our opinion. Again, we go through in our brief, and I'm not going to bore you with all repeating my brief, but there are legal definitions of what a business is. A business is something that produces active income. not passive income.
But when you apply for an LLC with the state of Ohio, an LLC is a business entity. So, I mean, it's a term of art you're trying to say that, I mean,
Sure.
isn't it a business entity? I mean, it may or may not ever make any money, but it's still a business entity.
Well, business entity, but there, I think there was a difference between owning a business or operating a business. You know, and then that was the thing, is that you had to list businesses that you own and operate. And he had listed, here's the weird thing
It
about it.
said own and operated as opposed to own or operated.
Correct, I think that in,
It may not make a difference, but
I don't know that it really does, and I guess here's my point, is that he is asked to list businesses that he owns and operates. I know that there was in, those were counts 9 and 10. What happened at trial was they had Alan Januzzi, he was the CPA for this business, and he had testified, look, I didn't know, in terms of who was dealing with the business, the only person I ever dealt with was this other attorney, Mike Tully. I never dealt with Mrs. Burge, I never talked to her about the business, she had no active role in it. The company didn't make any money, that was borne out by their tax returns. So is she running a business, Whiteacre North? I mean, to the extent that you have a business that makes no money, that doesn't generate an income, that isn't actively selling anything, is that a business? I don't think so. And I think that, you know, you go through, as we did, you can go through the tax code, and it says, look, non-business income is something that, you know, for instance, rents from real estate. So the IRS is saying, look, that's non-business income, but there's no definition even in the revised code of what a business is. There's no definition on even the Ohio Ethics Commission website as to what a business is, other than by example, and those are all money-making, profit-making entities, not a real estate holding. So is it possible that you could think legitimately that as a matter of law, this is not a business? Absolutely, and I think the scary thing is, what do? Is how do you possibly know as a fact something that is susceptible to multiple different interpretations by the law?
If, just being argumentative here,
Sure.
if in fact there was somebody got hurt on the property,
Mm-hmm.
isn't he gonna use Whiteacre North LLC as a shield to protect himself from any liability that's incurred on the business property?
No, because he had assigned all of his interest in the property to a third party, so he wouldn't care really at that point in time.
Except that he is, okay, and the other argument you're saying is that it wasn't a business because it wasn't making any money.
Correct.
Okay, if it's a failing business and he's responsible as a guarantor,
Mm-hmm.
then, I mean, isn't there some potential there that he'd have some liability if it's a failing business? I mean, it's gonna end up on, and businesses are gonna be able to pay its mortgage?
Sure, he's a guarantor on the mortgage note.
Right.
So sure, if Whiteacre North was unable to meet its mortgage obligation, he may have to pay in the future. And I suppose if the Ohio Ethics Commission had put in their disclosure forms, let me know of any loans you're a guarantor on, I think that it could have been disclosed. But whether you're a creditor, here's the problem. Let's say that he had said, yes, I'm a creditor for Lorain National Bank. Well, actually, the law says that a creditor is someone that you owe money to immediately. You're just a guarantor. You falsified your financial disclosure form in that way. You really can't win because, as Judge Crawford said in this case, transcript page 555, all of these issues, you can bring in 5 attorneys to say one thing and 5 attorneys to say another. So if you have 5 attorneys to say you are a creditor, 5 attorneys to say you're not, how is it possible that one person knows that he's not a creditor and his statements may be a fact that are interpreted by law can be the basis of a falsification or even a purpose to defraud? It doesn't make any sense because these are legal conclusions. And again, 5 can say one, 5 can say the other. That's why I also believe that this, really is against the manifest weight of the evidence. What you had in this case, you had 12 lay people looking at the judge's legal opinion as to the state of his own financial affairs. I don't think that there's any possible way that anyone could say that there was, beyond a reasonable doubt, evidence that anybody knew as a fact, because these are all conclusions of law, that he was right or he was wrong. This is a legal opinion, much like the Court of Appeals. It's going to issue a legal opinion. Not a legal fact, because the Ohio Supreme Court could say, well, we think you guys were wrong. This court can tell a trial court, we think you were wrong. But just because somebody makes an incorrect legal opinion doesn't mean that they falsified an opinion because they were wrong. And that's what's happening in this case. They're saying that, look, these things that have legal meaning and can be interpreted several different ways, you, Judge Burge, are unique in the fact that you know for a fact what the legal interpretation of these things are, but there are multiple attorneys testifying in the trial court. One says one thing, one says the other. Which one is right? These are opinions. There's also, because of that, really no purpose to defraud. You look at the tampering with records. What purpose would it have made for him to not disclose certain things? I mean, he went to great lengths to write letters to the prosecutor saying, look, just so you know, I assigned this interest to my wife. Turns out, weirdly, that was even wrong because the evidence in court was showing that Attorney Shimani Smith, to whom he sold the business, was still collecting rent, well beyond when this contract was supposed to have ended. The only real benefit to anybody, and this is, according to the Attorney General who tried the case, he instructed the jury, told the jury that if some of these things were disclosed, that Judge Burge could not be a judge anymore. That was the benefit that they said that he derived from making some of these mistakes or actually having a difference of opinion with the Ohio Ethics Commission on these things, that he couldn't be a judge anymore. That's absolutely not true. They've not identified any benefit to himself or detriment to another to support the facts of this case. So I think for both the fact that I think 12 lay people cannot, under these facts in this situation, determine guilt based on these legal opinions, plus the insufficiency of the evidence as to falsification and tampering with records, I think those should be reversed. The other thing, regarding the cross appeal, if I could, the state is arguing that Pelfrey was wrongfully decided. The Ohio Supreme Court decided Pelfrey. This court has followed Pelfrey several other times. There's nothing before this court or nothing unique about the facts of this case that should come with a different opinion. Pelfrey dealt specifically with governmental records and the omission of that additional element. These facts fall squarely under Pelfrey, and it's still good law. So I'd ask that this court reverse the opinion of the trial court, that this court discharge Attorney Burge from prosecution, find that the cross appeal and our third assignment of error is moot, and I think
You have 2:30 minutes left, and before everybody proceed, I didn't realize the emphasis on the Ethics Commission as much as perhaps I should have. I served on that commission for 9 years and just wanted to make that disclosure to you. If you wish to take any action and wish to get me off the panel, that's fine. We'll rehear the case.
Good morning, Your Honors. Catherine Mullen on behalf of the state of Ohio, appellate cross appellant in this case. I disagree with something that Judge Burge's attorney stated. I think this is actually a pretty straightforward case. We have counts of falsification and counts of tampering with evidence, or tampering with evidence. Now, the tampering counts, the defendant focuses primarily on this idea of defraud, that we had to prove that he was defrauding somebody. Well, first, I believe that we did, and it's for the reasons that the trial prosecutor stated, which is that if he had disclosed his interest, he would have disclosed conflicts of interest with numerous attorneys that were leasing space from him. That would have not precluded him, of course, from being a judge, but it would have made things more complicated when attorneys that had that landlord-tenant relationship were meant to practice in his courtroom. But second, he's missing the second half of the statute, which is the alternative level of proof, which is that not to defraud, but that he is doing it to facilitate a fraud. And in this case, I would argue that he's clearly doing it to facilitate a fraud, the fraud being that he doesn't have the interest in Whiteacre, that he isn't in a creditor-debtor relationship to Lorain National Bank, or his wife's relationship in those businesses. The fraud there is the fraud for the lack of disclosure in his financial disclosure forms. Turning to the falsification counts, we did have to prove knowledge. And I know the defendant argues that we didn't prove knowledge because maybe it was a mistake, or maybe the statements weren't false because there's different definitions in business law and tax law and other things. Well, when we get down to it, this is an LLC. It's a business. It was registered with the state of Ohio. Its Black's Law Dictionary defines it as a business. I don't see any way around it. The fact that maybe that wasn't one of the examples listed on the Ohio ethics form as, potential qualifying events, that doesn't mean that it wasn't something that needed to be disclosed. In fact, if the judge had that much of a question about whether or not he needed to disclose it, the Ohio Ethics Commission has a hotline that he could have called and gotten the answer really quick. The state of Ohio had, in fact, the Ohio Ethics Commission testified, and they testified that he should have disclosed the information. So I don't really see that there's a conflict here. The commission that's in charge of the forms came in and said he should have disclosed it. The forms, I think, are very clear. They're written in very basic knowledge. I know all of us have to do them. I don't think that there's much of a question in terms of his responsibility there. In fact, when you look at the evidence, he had disclosed on prior occasions his relationship with Lorain National Bank, and then chose not to. And then in 2014, after the investigation against him started, he tried to file amended forms with the Ohio Supreme Court. Now, the board testified that you can't file an amended form. That's not something that's recognized. But in filing the amended form, there was an admission on his part that these are things that he should have disclosed. So when we look at the evidence, which is credible because we're looking at documents. This isn't even purely based on testimony. This is based on the non-disclosure. When we look at that evidence, it's clear that he knew that he needed to disclose that. He went back and tried to disclose it later on. The last assignment of error that the defendant raised is a merger argument. I know he didn't discuss that yet with this court. But these counts, they do line up in terms of the financial disclosure form. So you have 2 counts for each financial disclosure form. That being said, we would argue that there's a separate animus and that the acts are committed separately so that they should not merge. Specifically, the tampering is complete when the non-disclosure happened. The falsification occurred when he signed the end of the form, which says, if you lie on this form, you're subject to potential criminal or civil penalties. That's the falsification, because in that point, he is affirming the false statement, the non-disclosure that occurred earlier in the form. So we would ask that those counts be maintained separately. Moving to the state's cross appeal, we do, of course, understand that this court is bound by State v. Pelfrey. However, we maintain that State v. Pelfrey is incorrectly decided, and I think the strongest evidence of that comes from Eford. This court has, on a couple of occasions, also looked at evidence outside of the verdict forms in order to affirm a higher level offense conviction, and I would point this court to State v. Henry and State v. Proctor, which I cited in my brief. The more recent decision of State v. McDonald appears to go back and sort of reaffirm what happened in Pelfrey, but it did so without reference to Eford, and it did so without overruling Eford, which means that Eford is still good law. Now, this state, of course, would concede that the defendant is correct, that the facts in Pelfrey align with the facts that occurred here, but that doesn't mean that Pelfrey was correctly decided, and we're attempting to preserve this issue for future review, if necessary. But we do believe that statutory noncompliance should be reviewed under substantial compliance rather than the strict compliance reviewed, or the strict compliance applied by Pelfrey. There's support from that from numerous cases. Of course, the dissent in Pelfrey, I think, does a very nice job of explaining that. But that being said, we do understand the constraint that this court had, and we would ask that this court consider the principles and purposes behind those decisions while we preserve this issue for future review. If this court has no further questions, the state's prepared to rest.
We have 9 minutes left.
That was fast.
All right.
Thank you, Your Honors.
I just don't want you to feel compelled to stop
No.
if you use up all your time. All right, thank you. And you have 2.5 minutes.
Thank you, Judge. Very briefly, I know that this state is attempting to say that there was a benefit to Judge Burge because there were individuals that could have not practiced in front of him. Well, the testimony at trial was, look, if there was a possibility some attorneys couldn't practice in front of you, you just ship a couple of cases to one judge, and they give you a couple of cases, so there's really no net benefit to anybody. That was testified to at trial. There's no benefit to Attorney Burge from doing this. And again, he's got legally
Wasn't
supported.
it more the perception that the clients that they're representing might be getting a better deal because?
No evidence of that at
I mean,
all.
no, but
I
isn't-
don't think that was an argument that was raised
But
at
isn't
trial
that what it
court.
suggests, though?
No, I think that what the state attempted to do at the onset was they also had Judge Burge indicted for soliciting improper compensation and having an unlawful interest in a public contract by saying that basically, he was giving certain attorneys that rented from him court appointments because they were renting from him. There was zero evidence that any kind of different treatment was provided to those attorneys. And those attorneys both actually testified, one of which is currently a prosecutor in this building. He says, I didn't get more cases, less cases, anything like that. So I think that was, there was no evidence presented on that whatsoever at the trial court. So Lorain National Bank, here's I think the biggest problem in maybe this entire case, in this entire, I guess, set of facts or what could happen in the future. You have an individual who for years does put Lorain National Bank as a creditor. I think wrongly, because if you really look at the difference between a creditor and a guarantor, technically a guarantor is not a creditor, and that's what the law says. I don't like it, maybe the Ethics Commission has a disagreement of law with me, but I think that it's legally supportable. He omits it 1 year and includes it every other year. And the Ohio Ethics Commission says, look, you cannot under any circumstances submit an amendment, we're not even going to consider it. So, as far as the Ohio Ethics Commission is concerned, really, there's no scienter requirement for any of these things. These are all strict liability offenses. If I submit a form that is incorrect through mistake, negligence, or misunderstanding of law, which this court has recognized in State v. Morrison, University of Akron trustee gives a loan to his son, what happens then? His son has a difference of opinion as to the reason for the loan. And this court says, look, there's no benefit to anybody. It's possible to make a mistake. It's possible that this was inadvertent. It's possible that this was negligent. What we have here is all those things plus possible confusion or disagreements on the law. Those do not constitute crimes, even though.
And now I'm going to have to stop you. Finish your sentence, and then you're done.
I would just ask that the court, again, find insufficient evidence as to the 6 counts, dismiss or discharge Attorney Burge from prosecution, find our third assignment of error moot, as well as the state's prosecutor. Thank you.
Thank you.